One day in Madison, hundreds of Wisconsin realtors meet their legislators face to face,
The goal was to create housing, but it never happened.
shaping the laws that affect your business and your clients. Stop harmful proposals, protect property rights, advance housing solutions. New or experienced, your voice moves the needle. Registration is free. Be the voice lawmakers listen to. February 10th, 2026. Realtor and Government Day. Advocacy in action.
Good morning, everyone, and welcome to Legal Landscape. My name is Wendy Hoang, and I am Legal Counsel and Director of Curriculum Development. And today I am joined by Jennifer Lindsley, my fellow WRA attorney and our Director of Legal Services and Licensing. Morning, Jennifer.
Good morning.
So today we're going to be talking about independent contractors. So, what is an independent contractor?
A lot of the classification of independent contractor versus employee, when we're talking about whether somebody is in one category or another, for the most part, what we're looking at is really like their status in taxes, what it looks like in taxes. But generally, an independent contractor is somebody they're on their own, independent, obviously, and they contract work with somebody else, and they provide services, but they're not employees. And oftentimes, they're compensated on via commission or by project as opposed to like hourly wages and not what you would think of for a typical employee. Another thing about independent contractors is because they're independent, if you were an independent contractor and I hired you, I would pay you based on what we agreed on, based on the work that we agreed that you would do for me, but you would be responsible for your own taxes, health insurance, and all of that. That's all you as an independent contractor.
Okay, so that's what an independent contractor is. So how, and you kind of went into the differences, so how does that differ from an employee?
The most fundamental distinction between an employee and independent contractor, well, there's a few, but one of the biggest ones is the amount of control that is exhibited over the person's behavior. So as an employee of the WRA, I was told, you're gonna go talk about independent contractors with Wendy this morning, and I said, okay, that's what I'm gonna go do, right? That's the level of control that my employer has over my activities. As an independent contractor, I could invite you and say, would you like to come talk about independent contractors with me? And you could choose whether or not to take that job or take that assignment. So that's the level of control that versus an employee versus an independent contractor. Another employees are usually wage or salary versus an independent contractor. You could negotiate with me and say, yes, I'll come do the presentation with you about independent contractors, but here's what I charge for my time. And then I could decide whether that's something that I want to pay, right? So we can negotiate that. That payment to you could be commission-based or it could be project-based. And then, again, getting into the realm of taxes, as an employee, I get a W-2 that states what my earnings are and what taxes I owe. Versus an independent contractor, you would get a 1099, and that's how you would file your taxes. So it's really, the distinction really does come down to one of tax classification, but broader than that, it is an element of control and how much, like you as an independent contractor, you kind of just design your own career and set up your own business and market yourself that way.
Sure. So agents tend to be independent contractors, but do they have to be? Is that a requirement of being a real estate agent?
It's not. Historically, many real estate agents have been independent contractors, and there's a variety of reasons for that. One is the nature of the business. When you're a real estate agent, you are creating your own business. It might be under the umbrella of your firm, under the marketing of your firm, but you are the one that is out there making contacts and working with sellers and working with buyers, and you're building your own business. So historically, agents have been independent contractors. They could be employees. It's not super common, but there could be a real estate agent who's hired by somebody who's very productive, and they hire the real estate agent as an employee to be a personal assistant. That might be a context where you would see a real estate agent being an employee instead of an independent contractor, but historically they have been independent contractors. I'm going to talk a little bit about these safe harbors for real estate agents. For the most part, like I said, they have historically been independent contractors, and it relates to these safe harbors for the tax provisions. I'm going to talk about the IRS one. This is kind of the next question, but we're going to talk about the IRS one and the Wisconsin one. Under the IRS tax code, there's been a special provision since the 1980s that's titled Treatment of Real Estate Agents and Direct Sellers. So when you're looking at the safe harbor, the notion of a safe harbor is if I do these three things, or whatever, however many categories you have, fundamentally, I will be treated as an independent contractor for tax purposes. That's the notion of a safe harbor. So I'm just going to peek at my notes here so I can get the provisions correct. But under the IRS tax code, this has been around since the 80s. It's the agent's license as a real estate agent. Their compensation is primarily commission-based. And then there's a written contract. So they're a licensed real estate agent, they get paid by commission, and there's a written contract. The IRS says if those three things are true, we will treat you as an independent contractor for tax purposes. Why does that matter? Well, then it matters because as the agent running their own business, then they can look at what types of deductions they can use from their business in terms of whether there was travel or different business expenses that they can use to structure the most beneficial tax picture for them as an independent contractor. In Wisconsin, in 2015, Wisconsin passed their own safe harbor provision to say for a real estate agent, if these things are true, you will be considered an independent contractor. And the Wisconsin safe harbor is there's a written agreement stating that they will not be treated as an employee, and at least 75% of their compensation has to come from commission. So those safe harbors, if an agent is operating within those boundaries, they will be treated as an independent contractor and not as an employee. And the reason that that is important, again, is because it could flip-flop them into a different classification for taxes. And if they want to preserve that status, they just need to maintain well, for IRS it's three things, for Wisconsin it's those two things.
Sure. So you mentioned the kind of two requirements, the IRS, so the federal, and then also the state, Wisconsin. So having that agreement, what does it look like?
In terms of the agreement, so both federal and state, you heard me say that there has to be a written agreement. What that looks like, typically that's an independent contractor agreement that you have to have that a real estate agent should have with their firm. So an independent contractor agreement, what's going to be in that is going to be dependent on the agent and the firm and how they want to structure it. There's not a state law that says you have to have A through J in your independent contractor agreement. It depends on how the firm and the agent want to structure things. But I just want to reiterate again that both for the IRS safe harbor and the state safe harbor, you do have to have that written agreement. And the written agreement will typically say, it might say what the compensation is. It might say whether you're allowed to drive clients in your car or what, if you have to have proof of insurance, what are the requirements. It might dictate if you have to go to certain meetings or attend certain trainings, right? All of that could be addressed within the independent contractor agreement. And I just want to clarify why we have these safe harbors to begin with. So the safe harbors, if we didn't have these statutory provisions in the IRS code and Wisconsin that said if a real estate agent does these things, they are considered an independent contractor. If that weren't true, what would happen is it would default to what's called an ABC test or this common law test, and we don't need to get too far into that. But the ABC test is the work is free from the hiring entity's control, the work's performed outside of the course of the employer's business, and the worker's engaged independently. And again, I don't want to get too deep into these details, but if we didn't have that IRS code and we didn't have the state statute, if a tax lawyer was looking at whether somebody was an independent contractor or an employee, they would go look at the test to see. The one hiccup where a real estate agent, where their status as an independent contractor could be threatened under these outside tests is the amount of control. So in Wisconsin, we have certain duties, and there's supervision responsibilities that a firm has as it relates to their agents. That supervision element of a firm and its agent, if we didn't have these safe harbor provisions, that element of supervision might just be enough to push somebody into the category of employee. And we don't want that, right? We want to preserve that status as an independent contractor, which is why Wisconsin passed that statute back in 2015, where it says, yeah, even though the firm does have supervision responsibilities for that licensee, and they have to review their contracts and review them, prior to closing, even though that all exists, statutorily they are still an independent contractor. And looking at the agreement, what does it look like? It depends. each firm can have their own independent contractor agreement. We do have we have a WRA independent contractor agreement that you can use. It's available in zip form, and it's also available in the WRA Forms library. So that's an option. If a firm, maybe there's a new broker out there that doesn't have any agents associated with them yet, but they're thinking about adding agents, and they want to have a written agreement, because that's the right thing to do, they can go look at the WRA's independent contractor agreement and see if that suits what they're looking for. If not, they can have their own attorney draft one. They can use that and modify it accordingly, but it's a place to start, and it gives at least some framework for what you would want to see in an independent contractor agreement.
Sure. So one of the things that kind of ends up in the hotline, I feel like is agents come and they ask something about leaving the firm or something, and a lot of the times I have to ask them, do you have an independent contractor agreement? And sometimes they say, I don't know. So what happens when an agent doesn't have an independent contractor agreement?
So there's two things that I'm going to talk about as it relates to that, and I agree with you. That's the most common context when this independent contractor discussion comes up, is you've got an agent who has left a firm or is thinking about leaving a firm, and they want to know, well, I'm going to go with that question first. They want to know, like, you've got an agent who's leaving a firm or they have left a firm, and they want to know, am I owed compensation from these transactions that I started before I left? And like you said, what does your independent contractor agreement say? So if an agent doesn't have an independent contractor agreement, they're going to want to go to their supervising broker and find out if they did sign one and they just don't remember it, or if they don't have one, then maybe they have a discussion about signing one now. So again, like I said, I want to talk two things about that. If they don't have an independent contractor agreement, I would encourage the agent, when we're done here, say, listen, I was talking with Jennifer and Wendy this morning, and they were telling me how important it is to have this independent contractor agreement. We should have this discussion. It benefits the agent and it benefits the firm in many ways, not the least of which is that safe harbor provision of making sure that for tax purposes, the person's considered an independent contractor. Secondly, it gives the framework really for the relationship between the agent and the firm of what are the expectations, what did we agree to, what's my commission going to be, anything. What's the expectation about me being in the office? What's the expectation about me responding to calls on a weekend? You know, whatever it is, that can all be detailed in that independent contractor agreement. If a firm doesn't have one yet, and which they should, an agent and a firm should have this agreement. If they don't have one yet and they're not going to use the WRA's independent contractor agreement, I would strongly encourage the firm to work with an attorney who's familiar with this concept to have them draft an independent contractor agreement. Because if there's too much control that's being exerted over an agent, that could potentially challenge their status as an independent contractor. So you wouldn't want somebody just kind of winging it and coming up with their own agreement. And back to like you said, the most common question we get on the hotline is, I've left a firm or I'm going to leave a firm. Am I entitled to any commission? License law does not dictate that at all. There's nothing in the state statutes, nothing in the administrative code, nothing in the listing contract or buyer agency agreement that says if an agent leaves a firm, are they entitled to commission for transactions that were started before they left? The only answer to that is you have to go look at your independent contractor agreement. And there are some, and if you don't have one and you left, I don't know what to say. Like, you have no legal claim to any money, even if you started the transaction before you left the firm. If you go back and you look at your independent contractor agreements, some might say, well, if it was your listing and there was an accepted offer and it closed after you left, you're entitled to X percent of what would have been your commission. Or if it's your listing and there wasn't an offer, whatever, the firm can have all sorts of different categories that whatever is suitable between the agent and the firm to dictate whether any commission is due after the agent leaves the firm and how much and what has to happen for them to earn that. I mean, have you had any other experience with that on the hotline, or is that kind of the fundamental question that you get to?
I would say that's pretty much the fundamental question. Another question we get, which you might be able to answer, is teams. So do teams play a role? Do teams dictate whether you have an independent contractor agreement or not, or whether you're an independent contractor?
That's a great question. Wisconsin does not regulate teams at all. And if you look at our license law recognizes the firm and the agents associated with the firm. They don't see anything else. There's nothing in between here. So license law recognizes the firm and the agents. However the agents choose to organize themselves within that firm is entirely up to company policy. And so if you're the supervising broker and your agents are organizing firms, you might want to have a conversation about what is our policy on this and how does that look, because license law doesn't dictate it. That's all internal policy in terms of whether teams are allowed, what they look like, how they function, how they're structured, where the money goes, who's responsible for who in terms of supervision. That's all regulated within the company. So you should have the firm and the agents associated with it. There should be an independent contractor agreement there. Whatever else goes on in between in the teams, those additional documents that structure the team, set up the roles within the team, those are not independent contractor agreements. That's something else. That's a different kind of contract that team is using to organize themselves. What you want to make sure is that whatever this team agreement isn't in conflict with or overriding provisions of this independent contractor agreement. So again, because that whole team business is unregulated by license law, the firm's going to want to look at what their policies are within the company to make sure that however the agents are organizing themselves as a team, they're not in conflict with the firm's overarching policies and their independent contractor agreements. So that's something to make sure of. One other thing about teams too is that if there's a team that's organized within the firm and those team agreements are exerting high levels of control over the agents associated with the team, that might potentially be opening up somebody to challenge whether they are indeed independent contractors. So there's nothing wrong with teams. They can be great and people can use them to very efficiently run their business. But we just want to make sure that whatever those team agreements aren't overriding or in conflict with whatever the independent contractor agreement is. One quick mention that I want to just mention this one thing is that we keep saying I keep mentioning challenges to independent contractor status. We've got our safe harbor in Wisconsin, which is great, right? That protects real estate agents. Where these challenges have come up, there's been ongoing litigation. Like California's been a real hotbed of this, particularly in the realm of ride-sharing apps and ride-sharing drivers, where they've been trying to organize and get themselves declared employees. And in fact, they just there was a lawsuit in California, forgive me, I'm going to get the date, recently, within the last 5-6 years, where they won, the rideshare drivers won and got declared employees. And then there was a proposition that was passed in California to say, these things are true. If A, B, and C are true, you are an employee, specifically except rideshare drivers and other like Instacart or DoorDash, other gig economy drivers. They were accepted from this, and so that proposition was then challenged, but that's been upheld by the California Supreme Court. So there's been a lot of movement in terms of whether somebody is classified as an employee or an independent contractor, and for a real estate agent to preserve that status as an independent contractor, that is so much of that status as an independent contractor is what allows a real estate agent to create their own business. It's within the realm of the firm, like I said, but it's that agent that allows them to decide how they're going to structure their business to be most successful.
Sure. So the differences between company policy and independent contractor. So the independent contractor agreement, as we kind of touched, is very important for building your own business. So if, for example, if I wanted to brand myself as the Wendy Group, I could put that in my independent contractor agreement, say this is what I'm going to be doing, or let's say I'm only going to be doing listings. That's what I'm going to be doing. And I could put that in my independent contractor agreement.
You could, absolutely. And if you look at the WRA's independent contractor agreement, which if you haven't, I would encourage you to do so. I would encourage everyone to go take a look at that. It's pretty straightforward. It's not 11 pages like some of our other forms or documents that we have. It just lays out the basics. It talks about termination, right? If I'm going to leave a firm, do I owe them any notice? Or if the firm wants to get rid of me, do they owe me any notice? So having that by having an independent contractor agreement with the firm, it can answer a ton of questions about what happens if there is a termination. What happens if How soon do I get paid after a closing? All of that can be addressed in the independent contractor agreement. And by having that, it helps the firm and the agent avoid getting into this area of unknown, of we don't, how do I leave my firm? What does it look like if I want to leave my firm? Am I entitled to any commission for those 3 listings that all have offers on them that are getting ready to close, but I got this great opportunity and it's not going to be a bad departure, it's just a new opportunity for me. Do I get any money from those? I don't know unless I go look at my independent contractor agreements.
Sure. So I'm just going to take a quick look here at the chat. We don't have anything yet. So we have a few more minutes, so I'm going to pose kind of a hypothetical here. So we talked about the differences between an independent contractor and an employee, and I feel like you kind of talked about this with the personal assistant, but is it possible to be both? So for example, let's say that I'm with a firm, I want to, do buying, selling, brokerage services, and that's all going to be independent contractor. I want to get paid on commission. But let's say I also want to be an administrative, coordinator or something where I'm doing all administrative tasks, but I want some more steady income and I want to be paid on a salary basis. Could I be both within the same firm?
100%. You absolutely can. And our safe harbor provision in Wisconsin specifically allows for that. There's language in the statute that says you don't have to be one or the other. You could be both. And it says that for you to be an independent contractor, then you need that written agreement, and 75% of the compensation that you are being paid is related to brokerage services, so you're getting commission, right? That doesn't negate the possibility that you could also then be an employee at the same time, and those are treated as 2 totally separate roles. So as long as the commission over here is related to brokerage services, and you're not getting salary for brokerage services, it's all compensation or commission based, and then you're getting salary or hourly wage over here for the administrative stuff, this is not going to threaten your status as an independent contractor. They're seen as 2 totally separate roles. So it's possible that that could happen. And what would happen then is for all of your brokerage services, you would get 1099 and pay taxes on that as an independent contractor. And then for your employee role, you get a W-2 at the beginning of the year, you get your W-2, and then pay your taxes based on that. And they won't, it's not going to be a conflict. So you acting over here as an employee isn't going to threaten the status as an independent contractor. And, we are entering tax season, so it's a good time for agents out there. Think about this. If you don't have an independent contractor agreement, you are potentially at risk for that status being challenged, and you don't want that, right? You want to make sure that you're preserving that. So make sure you have a written contract. If you don't have one, go talk to your supervising broker and say, let's have a discussion about this. It can only benefit you and your supervising broker. And when we get calls on the hotline and you ask them, do you have an independent contractor agreement? And they're like, oh, everything knows, it's just a handshake, everything's cool.
Yeah.
That might be great, and that might be how that business is run. But it doesn't benefit the firm or the agent to not have that. And like I said, it's not 11 pages. It's just 1 page front back, easy to fill out. So it's just going to help everybody involved.
Right. Even though, you might have that handshake agreement, as you said, it protects everyone. You don't want it to be the one time where things do go sideways where you don't have that, right?
I want to mention, too, one other thing. I was just thinking about this, that, again, if you don't have an independent contractor agreement or your firm doesn't have one, we did a legal update in 2025. I'm forgetting what month it was, but go back and look at our 2025 legal updates. There's just a nice little video about independent contractors, and it's something that a firm can share with their agents if people have questions about it. It can help clarify what the categories are, but there's just another resource out there if somebody needs a little more education on the distinction and why it's important to have that agreement.
Sure. So just another question before we wrap up here. You mentioned tax season coming up. We're not tax attorneys, unfortunately.
Oh, I think fortunately, actually, I that would not be for me.
Tax law is very complicated for those of you who don't know. But what if an agent has questions about, their 1099 or if they hold both positions, their W-2? Who should they go to?
So obviously, somebody who specializes in tax, whether that's a CPA or a tax attorney, you don't have to necessarily go to an attorney. Accountants are obviously very knowledgeable about tax law and will help an agent understand what is their best possible position tax-wise and what they can do to benefit that, to benefit themselves. But a tax attorney or a CPA or somebody that can help you with accountants can help you with that. But it's not something to dabble in for sure. Tax law is pretty complicated. And I remember when I took tax law back in the day, and
I didn't.
Oh yeah, and the professor was saying like there are 1,000 pages of the Internal Revenue Code, and I mean probably even more than that. And there's exceptions and deductions and all of the things that people can use to make sure that they are in the most beneficial position tax-wise. And he always said, you know, people say like complain like, oh, it's a loophole. He's like, it's not a loophole. It's in the tax code. You should use it. It's there for you. So, you know, take advantage of it and make sure that you're maximizing your benefits by minimizing the amount of taxes that you owe using that. So it's advantageous. If you need a tax lawyer, though, the state bar has a lawyer referral and information service that you can contact and say, I need somebody who does tax law, I need somebody who does employment law, or whatever the case is, and they do referrals out of that.
Sure. All right, we have a couple more minutes left, so I'm just going to take a quick peek at the chat. If you have any burning questions to ask Jennifer here, now is your time. And we'll wait just a few seconds just so you can type it in and we can get those answered for you. Don't see anything yet.
So we have just a few minutes, so I'll just wrap up with just a couple things. I just want to remind everybody, we've said it 1,000 times, make sure you have that independent contractor agreement, know what's in it, know what your rights and obligations are under it, and like I said, it can only benefit everybody involved. So go take a look and review yours if you haven't in a while.
For sure. All right, nothing in the chat yet, so with Jennifer's last words, I think we can wrap up here. Thanks, Jennifer.
Thank you.